My name's Mark Hilliard. I'm the patent counsel, and it's my responsibility to report Argonne's intellectual property and to protect the same, manage the protection of it.
I am Hemant Bhimnathwala. I'm at TCP.
And Hemant and I are going to discuss all the ins and outs of patent basics. Jeff's done a great job highlighting what we're going to be talking about, and the same ask a question, if you wish, at any time is available to you. We'll go over the process. I'll mainly go over the process, which is at times not that exciting, but it's very necessary. And Hemant's going to talk about the benefits to the lab, to DOE, and I will be reiterating the affirmative steps you have to take to protect the IP, because as you've heard already, if you disclose the invention, you lose your foreign rights, and you must take action within 1 year to preserve any U.S. rights. So let's see how this thing works. The first question for a legal issue is what is a patent? And a patent basically is an exclusive right created by the United States government, and the idea being that it encourages inventors to not keep their inventions secret, but to bring them quickly to the attention of the public and receive a limited monopoly for 20 years. And that monopoly is an exclusive property right, and property can be sold and licensed, and that can end up with royalties returning to the inventor or the patentee. What do you need to do that? You have to invent something. We'll talk about what that means, the ideas of novelty, non-obviousness, and then you have to file a patent application and go through a formal process of having your application approved.
So as Mark just mentioned, IP is really a property. Argonne, as a DOE lab, cannot sell the property, but it can actually license the property to a commercializing entity. The other use for patent is really it qualifies your work, qualifies the quality of Argonne's work, and you can actually advertise in your materials that Argonne is good in certain respects. So why do we file for patents? As Glenn mentioned earlier on, this is the patent contract. How we can create impact in the society, and essentially that's by commercializing our inventions. There's differences in how, as I mentioned, Argonne deals with his IP versus industry. So for example, have you heard of EpiPen? Right, so EpiPen is using their IP to generate huge amounts of profit for themselves, right? Argonne can't do that. Argonne is not in the business of selling products, right? What we do is we, in fact, license, right? So when you talk about licensing, and we talk about licensing a new product or a new service, you may want to think about that you really are solving multiple problems that go into a product. So you may really want to think about a portfolio, not just one patent, but solving multiple things that actually make a new product. Other difference really, if you consider, for example, how Intel deals with this patents versus how we deal with it, right? They talk about a huge number of patents. When they deal with, for example, Global Foundry as a competitor, they will say, well, I have 100 patents covering this area, you have 100 patents covering this area. Let's not sue each other. Let's cross-license. Argonne can't do that because we are not in business of producing things. So what we really want to focus on is quality of a patent that can solve an important problem, and you can actually license this out. Let me just bring this up. I think the whole process on the left side, from invention disclosure to a license, Mark is going to talk in more detail as to what are the various steps we go through and the subsequent sites. What I really wanted to highlight over here is a question that somebody asked at the back, is what is the benefit to a PI on filing a patent? Well, at the time you file a patent, each inventor gets $250 for the disclosure up to maximum of 6 people. If there are 7 people or 8 people, you kind of share the 1,500 among the inventors. When the patent is issued at the end, each inventor and co-inventor gets $500, and if again there are more than 6 people, they kind of share the pot of $3,000. That's important. That's the financial benefit to you. And after all, if you have an important patent that a commercial entity actually wants to license, you share in the royalty income. As Suresh mentioned, 34% goes to inventors, 33% goes to well, it says division, actually ALD, and 33% goes to OTD.
This is a flow chart for the first part of our process for reporting inventions to the laboratory. The thing I would like to emphasize here is DOE, okay? If Argonne if the contractor, if Argonne never filed a patent application, our contract, your employment agreements would require you as scientists to report your invention to DOE, and through us, of course, and Hamid explained all the benefits that DOE has provided with inventors receiving a third of the royalty income, if there is any, which is a very good benefit. And the reason DOE or the government's doing this is DOE recognizes that the research dollars provided to develop the science, that patents are a valuable, possibly very valuable product of that. And they want to capture that value for the government resources. And this was even during the Atomic Energy Commission days. DOE's patent attorneys would protect the lab's intellectual property. And we have in the back, I'll introduce Mike Dobbs, who's the head DOE IP attorney. And there's a whole a number of other attorneys sitting next to him. And we will discuss it in detail, but at times the lab, often for cutting edge science that's very important and that DOE is very proud of, often the lab passes because it may be 30 years before you ever have a commercial use for that patent. And DOE then will take Argonne inventors' inventions and patent them. And at times, DOE even provides that basic patent back, maybe 15 years later, 10 years later, to be licensed with a portfolio of newer inventions that the lab has patented. So starting from here, that's sort of the goal, the main goal. But it's not the only goal, because TCP, representing the lab, as you've heard, file 80 patents or whatever a year, and it provides support for all the other commercial relationships we have. So Jeff has gone over the importance of paying attention to your inventions as you're developing. What I call identification, which is a simple form that you can fill out, a simple web form, but we're a small organization, and if there's an invention that you want to bring to someone's attention, you can bring it to Haman's attention or whatever. Hopefully he will force you to go to the website, because that puts it on our queue, but we can work flexibly with you to get it into the system, so we'll review it. After we receive the initial idea that you have an invention and you want to report it, then we have to develop a invention report, and that DOE requires certain information. Basically, it's who do we think are the inventors, who contributed to the ideas that may be patentable, what is the funding, and that's a very important thing where I'll introduce Debbie in a minute, but it's a very important thing for DOE to obtain the B&R code for each invention, and the reason for that is DOE uses that DOE programs who fund your research and whatever use that to show one of the good benefits that come out of each program, and that's useful information, so that's why we always ask for that. It's put in a formal form. You have the ability to amend what and I should say what typically happens, you might send a paper or a paragraph or two describing the invention. We put this into the basic form. Debbie works with you to get a signed copy of that invention, and then that is formally reported to DOE IP at the same time. And this is a simple slide to show that it's that'll show up a platform to fill out this information, get the process started. You will receive an invention number back, IN 17 whatever. And the reason I bring that up is if you don't have an invention number, ask for one. And why? Because the invention number shows that we put it into our queue, we're working on it, and we won't lose it. And if someone says, I reported that invention, patent counsel might say, what's the invention number? When they said they don't know, then it means maybe they need to report it. Maybe they thought they talked to someone about it, but they didn't. I threw in the software information because we're not going to go over today. The software copyrights is another. The other important intellectual property exclusive right that can be licensed has brought a lot of money and importance, helped commercial relationships with the lab. But it's the basic same idea. Bring it to our attention. Here's the A&L 1032 link or form number. You can find that, or you can ask anyone from TCP or legal. And we have a similar simple process to capture that IP. I've mentioned Debbie. Debbie Kukowski is sitting back here, and if anyone's dealt with patents, you've dealt with Debbie. There's a lot of paperwork in these processes, a lot of back and forth, and she takes care of all, including interfacing with the outside counsel when we go on to file patent applications. After we have the signed invention report, we need a signature on it, except for exceptional circumstances. We send that to TCP, and TCP then is responsible for determining IPG.
So essentially what happens is once legal and Debbie pass over the invention disclosure, TCP organizes what is called an IPDG meeting, right? IPDG meeting, as it says, and I think Jeff mentioned, it invites all the inventors, invites the division management or the management for the PIs, has Mark Hilliard in the group, and as somebody from TCP who's a business development person working on the commercial aspects of the patent in the group as well. And we sit together. Initial format is that the participants, the inventors, will describe what the invention is, what's the novelty in the invention. That's really a technical discussion. And after the discussion, Mark Hilliard is always in every IPDG meeting, and somebody from TCP will go over and discuss the legal aspects. For example, if there's a disclosure, early disclosure date, for example, what is the novelty, what is prior art. I'm just throwing that, we'll probably discuss that in other slides as well. And then the TCP folks will talk about what is the potential for that invention. Is there something so specific that can only be used in one lab somewhere in the world, or it has some broad application and you can generate substantial amount of royalty income. So those are the two ends. Or sometimes, it's just neat, but there's no really application, right? So we talk about all those in the IPDG meeting. So as I said, that the evaluation criteria is, we are not the decision makers in issuing patents. This actually goes to USPTO. So we kind of figure out if this meets what are the basic needs for or it meets USPTO's guidelines. And then also on the licensability, as you can see, Mark will talk more about the legal aspects, and there's several legal aspects, and he's got a lot of slides to talk about that and a lot of details. But TCP folks will really talk about the licensability, right? Is this something that can be commercialized? And are there companies which can actually take it and make it a reality? Remember, IP patent is a negative right. It doesn't allow us or PIs, anybody, to force somebody to invest more money to make it commercial, right? So it just prevents somebody else to infringe on the patent. Again, as I said, right, the last one said that sometimes it's nicer to have a platform because that can lead to a lot of applications rather than something which is a very small point application. Coming back to the IP decision meeting, as I said, right, go through the process of presentation and a discussion, and the three outcomes that comes out of that meeting. One outcome is, well, decide that this is valuable, and we actually want to file a patent, right? That's a good one. That's a very good outcome. The other outcome is, well, it's a little early. You need to show more demonstration, more reduction to practice, and we hold for additional development, right? Or you want to add more claims to what you think you can put in there. And then finally, at some point in time, we decide, well, you know what, we are not ready to actually file for patent yet, and we decide we return to DOE.
I wanted to make a comment because there was an earlier question about the idea of returning an invention to DOE, and there is an option. It's with the lab's approval for an inventor to request title to an invention from DOE. So once the invention is returned to DOE, it's DOE's IP attorneys review it to see if they want to file on it, and they have limited resources, so they can't file on everything. But some inventors would like to obtain the rights, the title to the invention. To do that, you have to meet the same general rules that the laboratory has to meet, which are you have to file patent application a year, et cetera, and the government rights, licenses, et cetera. But you can contact DOE through my office. What I do is I check and see with the Hamant whether the lab approves of this, because you can see there may be things where it would affect the lab's investment in a large portfolio or commercial relationships. So there's a question of whether it can be approved, but it often is. So that's an option for the return to DOE. I would like to emphasize also what Jeff said. I think it's a great way of looking at this, is the IPDG meeting, it's not just to talk about think of it as a selling job, not in the bad way. And I would even step back to make it sound like it's easier for you. I assume to get funding to develop your technologies, to work with the DOE programs I've never done, you have to sell your capabilities and what you're doing from inception, way before this process. And when you do, you get some funding, or you have a concept that will build a new program, and your program manager at DOE says, oh, this is great. All of that is the same idea, how important it is, and you have some textual information on the proposal and some work, whatever. It's the same idea. You have that done for a lot of your inventions. It's bring that enthusiasm for the technology to this meeting, and your management is invited to this meeting, and when they can, they attend, or the representatives. The other thing with the meeting and the IPDG meeting is that it's not just for the one invention we're talking about, especially, for example, like Jeff, over the years, I've been here 17 years, so I've been to a lot of IPDG meetings. And the one thing I see is the side conversations that I might not even be involved in about, oh yes, and then it's an opportunity to talk about what's happening with this, what's happening with that. So you can bring all of that interest to this meeting and use it as a tool to review your portfolios or get any other questions answered. Assuming that the decision out of the IPDG meeting is to file a patent application, then the goal is to get an issued patent. Well, to do that, you have to file a patent application. You have to prosecute it. You have to file this application in the patent office, and you have to meet the patent office's requirements, which are simply the requirements of the federal law that establishes the whole system. So I'm just going to touch on these, but the basic ideas of a patent is you have to establish that when you file the patent application in the United States Patent Office, and I will reiterate this to the point that it's too repetitive, but sometimes inventors think that that signed invention report that we use internally to get this process going protects them from their disclosure of the invention to the public. But that's not true. We have to go through the full process, develop a patent application, and file it in the United States Patent Office. And in that application, you will show or describe technology and claim the novel features of it, which means it's new over the prior art that exists prior to that filing. Okay, and that can be printed publications and public disclosures of any kind. You also have to name the correct inventors who contributed patentable subject matter. And here's an important point too, because everyone, I think, or most people that know patents know it's a race to the patent office. It's first to file. It's important to get it filed quickly, but it's also important to provide the most detailed description that would support a claim, okay? Because if you don't have the detailed description or claim, the fact that you're a day before someone else does not remove their ability to get that claim. And you never can put every idea into a patent, to cover everything. You don't have the money and research, but you want to be first to the patent office with your best error-free specification possible. There's also a concept of obviousness, which is the same as novelty in the sense it's new. There's some tweak that is different than anything we can find in the prior art. But the question then becomes, is that just an obvious, routine choice that one skilled in the art would make? And that's the United States Patent Office to make that last point. For anyone that hasn't seen a patent, to fulfill your obligation to provide a written description of invention, how to make, use, and sell, that's what the public gets for the 20-year monopoly the government's giving you. You need to describe it. So typically there are drawings, there is a specification, it's called, that describes that technology, referencing the drawings typically. And then there are a strange thing at the end called claims. And claims are a legal part of the patent application. The very general idea is to draft the claims as broadly as you can to cover as much as you can, because remember, they define your exclusive right. So if your claim is too narrow, someone could capture the commercial value of your invention outside the narrowness of your claim. So that then is always in view of the prior art. And each claim stands on its own. You'll see dependent claims in a modern patent. I don't think I have any here. But they'll say, as in claim 1. It's just a simple way of not printing the same words over. You just take everything in claim 1, put it in claim 2. That's the whole claim. The claims define who owns any individual patent. Okay, so if two inventors are contributed to claim 1, and there's one inventor that contributed all the claims to claim 1, and then you cancel the claims out, they can change the ownership of the patent. So when it comes to discussing whether an invention is novel or whether someone owns a particular patent, you have to look at each claim. It only takes one claim where you've made a patentable contribution to one claim in a patent, and you are inventor for the whole patent or patent application at that moment. I think you've already heard this, and this is one of the most important takeaways I put at the end here, is that when you publish, you lose all foreign rights. But you don't think you've lost everything. You have in the U.S. 1 year to file a U.S. patent application. But if you have a great invention, you want to file that U.S. patent application before you publish, because there's some question on what effect that has. The law is new. It can't. Your activities, your publication can be removed as art, but there's still some uncertainty there. So the best thing to do is to file. But if you can't, we still file many patent applications within 1 year of a disclosure. One way of preventing something to be a public disclosure for patent purposes is to work with the outside party before you disclose the invention to them to sign a non-disclosure agreement. And that then keeps it from being a public disclosure, and it doesn't have the effects on the patent law. The other thing is if you are publishing a paper, typically the review process is confidential. It is only supposed to be used for purposes of reviewing the paper. And in that case, we don't consider that a public disclosure. But we're back to my original thing that if someone breaches that and puts it on the web, you probably don't have any ability to get your invention back. So you want to, if you can, start this process early, come to some conclusion, and if it's really important, file that patent application, which I think is what the best practice tells you to do. Finally, I'll quickly run through the patent application process. So we engage outside attorneys, patent attorneys, who draft patent applications for their living, and they, in a technical area where you work. So we use different attorneys depending on the technology. You can see in this timeline, and this is a little bit theoretical, these can take all different amounts of time, and it could possibly be done much quicker. But in reality, after the invention's reported, a meeting is set up depending on the parties and et cetera, the availability. We can file a patent application. These green lines are interesting because they tell you what's the inventor's input. That's the time you'd be actively working, as Jeff has mentioned, with patent attorneys, or in this case, maybe with TDC, et cetera, or this is with the patent attorney. And this is for later when you're doing the office actions, which I will explain. But pay attention to that, because that's where you as a scientist would be actively working on the patent application. So when the patent application is filed, typically in 18 months in the United States, it'll be published. So you will, if you filed a patent application, you can probably find your patent application 18 months after filing on the web, or I could provide it to you, whatever, if you ask. About 30 months in, and it's variable, it can be even quicker at times, you will get a first office action. Typically the first office action, this is probably getting a little bit too detailed, but is what's called a election action, and what happens is of the 20 claims typically filed, there'll be 3 chains of independent things, and the patent office for their fee structure will say, there's 3 inventions here. You're going to pay fees for all 3 if you want them, okay? And what the process typically taken is you choose one. You elect one of the inventions. It could be one of the groups to prosecute first. You're not abandoning the other inventions. They can be prosecuted later. In fact, you could file 2 new applications immediately, but no one does that because the first one you prosecute will bring prior art to your attention and the attitude of the examiner to your attention. And what you typically do is you wait till you have convinced the examiner to issue the patent on the first group of inventions, and then you decide later whether to file a divisional application, which is one type of later application. So that's typically the first office action, but a substantive office action is one that always comes later, or might come initially if they're not restricting your invention out, is that the examiner is going to do a patent search or public art search and find things that you didn't provide the examiner, which, by the way, I didn't mention, but you have a duty to tell the patent office the relevant public information you're aware of that could affect your patentability of your invention. But you may have a patent, say, or a publication on the same art, and you've changed the art in a certain way. You need to provide it to the patent office. Patent office does its own search. It writes an opinion challenging your right to have a patent, typically saying it's not novel, and each claim stands on its own, so they address every claim. And then you work with the patent attorney, outside patent attorney, over a period of months to develop an answer to that. And this goes back and forth to the patent office feels all the, the substantive issues and the technical issues are dealt with, and that they can issue the patent. And once that happens, I guess this is about, I have about 40 months or whatever, that process. And that process can take a long time, and it can also require an appeal where the patent examiner continues to reject the application, and you then appeal this to another appellate board and have that reviewed. After that, there are some things you may have heard of, just for general knowledge, that a patent, you have to pay maintenance fees after it issues every 4 years. So the lab takes care of that, reviewing whether to pay those fees. And I think you've heard that this, I just give you some statistics to see what the patent numbers are for the last fiscal year. And do we have any questions?
At what point does the IP become licensable? Do I have to wait all 40 months? Or if you have the, let's say, provisional patent filed, and at that point, could a company come in and say, hey, I want to license this? And we can wait until the patent is issued, but we would like to exercise the technology and essentially commercialize it. Is that a possibility?
Yeah, you can license a patent application. Licensing attorneys may have some comment on this, but I think you could license a concept. It's a license being a contract between private parties to license rights coming. But in reality, you want to file the patent application first, I think. I mean, the best practice is at least get the patent application in the patent office, put your stake in the ground or whatever you want to say so that the patent office has a record and that's your date. I think that's typically what's done.
Right, so I think your question is, can you actually license it before the patent is finally issued? Yes, you can. Although, if the patent is denied at some point in time, the licensee is going to stop paying. But yeah, you can license it. And we have done that.
Hi. So my question pertains to one wants to patent something as an idea, and that's not pursued, as it turns out. So then it has to be reduced to practice in order to proceed. And to get funds here at the lab, if the funds are from LDRD or someone's boss or something, that can be doesn't always work and can be challenged. So if one wants to try to get funds, say through a grant to the NIH or Department of Defense or the Gates Foundation or something, is that public disclosure to put those ideas in a grant application?
And all of the idea of, it probably is, okay, or I would think it may be, but it comes down to the facts of, there are, I think, grant programs that allow you to mark certain parts of the grant as patentable subject matter. But if you don't have that, if the party is free to use it, it may be a public disclosure. And I think Jeff pointed out maybe you can, and it probably can't, but maybe you can not give away the exact idea you have at the moment. The first part of your question, I don't know if I understood it as far as the conceptual nature of it. You can file a patent application or file patent and obtain a patent on a purely conceptual invention. There's a lot of reasons not to, but you can do that. So was that part of your...
Actually, along with Jeff and someone else, we did try to get a patent something as an idea, and it was rejected. The lab chose not to go forward with that. So I have to find another way to get funds to actually reduce it to practice. And the lab's not supportive in that way. So I have to go outside. I'm trying to figure out how to do that.
And I didn't really address the idea of conceptual invention reduction to practice. Often you can have a broad conceptual invention. The only thing I'll say about that is, say you do get funding and you can't get a patent on it. Say you had to disclose it and it's more than 1 year on the very broad concept. Often the reduction to practice leads to another invention, leads to a more detailed invention, but a very commercially valuable invention, and so I think it's a good thing I haven't done this yet, but I think one of the most important things to do as a scientist is not to fall into the one-on idea of patents, invention, reporting these things. I've reported my invention. I went through the IPDG, either they didn't patent it or we did patent it and it didn't work out and that's it, I'm done with that. Okay, that's a waste of my time. And from being here a long time and seeing some very successful groups of inventors, and probably all know them, it's all public knowledge, from all different levels, and there's a certain amount of luck to being a very successful inventor. You can have great science, best patents, but the commercial market has to value it for whatever reason. But it's ones who build this concept into their job over a whole career and continuously take their next best thing and see if they can get a patent for it and hopefully get half them or whatever. And because of that habit is what will cause you to, luckily, pick the one that now, 5 years from now, is your giant winner for your whole career. Whereas if you quit after doing a few of them, you won't do that one. And you'll realize later, maybe when you realize it, that was very valuable. So the idea of building your own portfolio of best ideas, Jeff said it, we tried it, the whole idea of our review of this is to keep it simple, have a simple IP or a simple invention report, not put a lot of burden on you to do searching or anything like that. A lot of this evaluating information that we show on IPDG, that's not your job. If we ask you a question, do you know anything from a commercial standpoint? If you don't worry about it. Don't stop doing your science. Just come to the meeting for an hour and talk about it. And I think that's the best takeaway is if you have
Hello. I have multiple questions. So first of all, about this 4-year maintenance fee, what happens if people don't pay for the patent?
don't pay the maintenance fee, the patent expires, and the public is free to use the invention that you just claimed or disclosed in the patent.
How much are they?
They raise over the years, I don't have it memorized, but it's like $500 for the first one. They go up like $1,000, $2,000, $4,000. Typically, most places pay the first fee without thinking about it after that large investment in patents. The second, it's a little bit more of a review, but when you get to the last one, we often don't pay them because it's a significant fee, and by that time, you have a better feel for if someone's interested in licensing the technology.
Okay, thank you. Then the other question is like this 1 year of disclosure, is it like universal or is just an Argonne?
Is it just, I didn't catch the last part.
So 1 year that you can like publish and you have 1 year to submit application.
That's only in the United States.
Okay, so if like patent was issued in United States, but when they searched, they were not really looking that it was actually published somewhere outside United States, does it reverse the public?
First, for prior art, the 1 year grace period, it allows to remove a publication of the inventor who later files a patent application as prior art against that inventor if they file the U.S. patent application within 1 year of their first publication of the idea in the U.S., okay?
In the U.S., but if he published somewhere prior to this, somewhere outside U.S., it doesn't matter.
No, it can be published anywhere. Any publication anywhere in the world is a public event. But the grace period deals with after you have that public event. Say you publish in France, as the inventor, you publish in France, you still have 1 year from that first publication event. Since it's yours, you're the inventor, you've published that, you can file a U.S. patent application as the inventor.
But what if you don't disclose that, France, and the patent office didn't find that publication in France? What happens then?
Well, you have a duty to disclose. If you show it to me, it's going to be disclosed because we have a duty to disclose any relevant prior art to the patent office. And with today, and I don't know where you're going with this, but with today's technology, the patent office is probably pretty likely to find it if they do their job. But you can have someone hide prior art and get an invalid patent. I just don't, it wouldn't be something to do.
Google is pretty good at picking things up. Try it.
Okay, so basically, if they don't, and you know about the existing publication, you can actually reverse the patent? Then its patent is not valid if you can find the publication that it was, the inventor did not disclose the previous publication.
Yeah, I mean, that's, are you saying that if you file a patent application and then someone finds out that there's a piece of prior art more than 1 year prior that they should have disclosed?
Right.
Yeah, there's all kinds of processes for validating that patent.
All right, thank you.